So I'm going to put the slide up so I have here Miss Judy Bone, and she is part of our legal team here at DOE. And I have the slide on the screen is the harmful to minors statute that we've previously talked about. And I'm going to let Judy take it away.
It's nice to be here to talk to the group. As Amber said, my name is Judy Bone. I'm at the General Counsel's office, and I've been there since 2007. But I must tell you, this is my first time talking about harmful to minors and pornography. So I will give it my best go. That all materials, as you all know, all materials selected for the school libraries must meet 3 criteria, and they must be free of porn and free of materials that are considered harmful under 847.12. They must be suited to student needs and ability to comprehend and appropriate for the grade and age level. Now, if I can, there was a discussion on materials that are harmful to students under 847.12. And if I can, I will point you to maybe the next, if I can. Amber, go to the next slide if you would. Under subsection 5, an adult can't distribute to minors on school property materials described in 3. And now if you go back to 3, and those materials are those that are considered harmful to minors, which include explicit and detailed verbal descriptions or narrative accounts of sexual excitement, sexual conduct, and that is harmful to minors. Those 3 terms, sexual excitement, sexual conduct, and harmful to minors, those 3 terms are defined in the statutes. And if I ask you, Amber, to go to 847.01, sexual excitement is what we would typically think of as a state of sexual arousal. Sexual conduct is what we would typically think of, for the most part, sexual intercourse, masturbation, the lewd exhibition of genitals. And let me just say that those sort of detailed narrative accounts of those things are prohibited if they are harmful to minors. And harmful to minors, it really entails the constitutional standard for obscenity modified for minors or for students under 18. And what must be shown for it to be, for these sort of depictions to be harmful to minors, they must predominantly appeal to prurient interests. Where is that show? Yes, I'm sorry. Yeah.
Prurient, shameful
or morbid interests, and they must be patently offensive to prevailing standards in the adult community as a whole, with respect to what is suitable material for minors. And also, taken as a whole, the material is without serious artistic, political, or scientific value for minors. And so I must point out that that's a rather high bar. Let me just say that the third prong, where you say taken as a whole, you're not looking at individual passages. You're looking at the entire book to see whether or not there is serious artistic, literary, political, or scientific value. So you're not, and I heard last time that some talk about looking at individual passages. I don't know that looking at an individual passage is going to help you reach the criteria for harmful to minors under this statute, because you must look at the material as a whole. And I can also tell you that these 3 standards, that, let me just say generally, they predominantly appeal to a prurient or shameful interest. They're patently offensive under the prevailing standards, and taken as a whole, they lack value. Those are, broadly speaking, the constitutional criteria for what's obscene or pornographic.
Okay. I see that someone has their hand raised. So if you have and this is again is for work group members only. If you have a question for Judy, this is your chance. So, who has their, Jennifer, go ahead.
Yes, thank you so much for being here. And I know across the country and across the state, this has been a huge debate. So my question is, I've read the statutes in and out. We've discussed them at school board meetings here in Indian River County. We've discussed them with the sheriff. And I think that everybody's opinion of harmful to minors is different. And it's not clearly defined. And if you look at books and you say you can't just look at one passage, you have to look at the entire thing. You know, I may say this is acceptable for my child, but somebody else may say it's not acceptable for their child. So how can you have a definition of harmful to minors without it being clearly stated? And what advice can you give us as a work group to be successful in making this recommendation to librarians and media center specialists?
Well, if I can, let me say there's a lot wrapped up in that. So let me see if I can start.
So like, could I give you an example and we could like discuss it? Or, I mean, how could we like be effective with this?
Well, let me tell you some things, what I can help you with and what I can't. Let me just tell you, I don't know that I can tell you whether any particular book is going to meet the standard for pornography or 847. I don't think that I can do that. And I recognize that there is some, let me just say, some subjectivity to the criteria. But some things, let me tell you, what you're looking at, for instance, on the provision dealing with the patently offensive to prevailing standards of the adult community as a whole, you're not looking at what you want for your child. You're not looking at what the most delicate of us want or what the most core of us want. You're looking more broadly than that. You're looking at, let me say, the adult community as a whole. Now, I know that's hard to quantify anyway. The way I think of it is like the reasonable person, that sort of thing. You're not looking at either extreme.
Right. So like if you can't say it at a school board meeting, or if you can't like print it in the newspaper or say it on the radio because it's against the community standard, is that what we're kind of discussing as far as harmful to minors against the community standard?
Well, let me say that I don't know if I can answer that because I don't know exactly what we can do on what those standards are for what's on the radio. I just truly, that's outside of any of my area of expertise. But let me just tell you a couple of things. As I said, you're not looking at what you want for your child. It's much broader than that. And I said that you're picking things for libraries and library materials, you know, all the way from, you know, elementary school to, and the statute even tells the media specialist to pick materials for students who are advanced. That's part of their duty too. So I'm just saying there's a broad range. And I also tell you, let me just tell you the other thing to think about is, I know, let me just, quite frankly, everybody's concentrating on this porn and harmful to minors. Quite frankly, y'all, those are crimes. There are other standards that you may need to be looking at a bit more closely that may get people closer to where they wish to be. So is to have a, you know, useful library and not to offend some people. I think that those other standards dealing with suited to student needs and ability to comprehend, as well as appropriate for the grade and age level, may get people closer, other than looking at, is it really pornographic?
Chris Smith, go ahead.
Let me figure out how to take my little hand down. I'm just wondering, for ease of sake, do we, for this specific subject, do we just need to simply put the state statute up and say what the state statute is and not try to define it? Because I think that's where you're going to have, I mean, unfortunately, I don't think that this group's going to be able to come up with a useful solution. We just need to state, this is what the state statute said, and pick the slides that explain this, and that's state statute. That's my suggestion, is we simply include state statute.
That is, let me just say, that's where I think would help everyone. So everyone knows what the actual standards are to meet. What are the decision points that you're going to have to find for a school board or a school district to have a book in the library or to remove a book from the library? So if we quote the statute for them, these are decision points. You know, taken as a whole, is there any serious literary value? Is that, does this predominantly appeal to a shameful or prurient interest? Third, is it patently offensive based upon the prevailing standards and, you know, as a whole? So that is my suggestion. I don't think, let me just say that looking at all the case law, it is sort of case specific. So I don't know doing anything other than quoting what the statute tells us would be helpful.
We talked before about, you know, possibly laying out, statute says, you know, we have to follow this and do this. And then, you know, here are some possible practices or ideas that you may want to consider in your district. That would also be an option. Julie Dashel, go ahead.
She may need to be unmuted. I'm not sure if that's been done for her.
She should be able to, but we'll go ahead and skip to Michelle Beavers.
Okay, so it sounds almost like anything goes at that point. If you're going to say that it doesn't really matter what the passages say, and that we're going to quantify it and say, but everything has literary value or wouldn't be in a book. I feel that we're talking in circles a little bit here, because you have to look at some of these passages to see if it's going to meet the idea of sexually exciting and all the other words we put in the statute. So I think you're missing the point here. You can't just say we have to look at the entire thing, period, so that there is literary value, so that we cannot take anything out of the reach of kids that shouldn't have it.
So if I can, so that's the starting point. Let me just say the starting point is there a narrative description or account of either sexual excitement or sexual conduct? That's the starting point. But that's just the starting point. For you to determine whether or not it's harmful to a minor, all those other decision points are going to have to be looked at. So well, I'm not saying you don't look at a passage, that's going to be your starting point, but then to determine whether or not it qualifies as harmful to minors under that statute or pornography, you're going to have to look at those other 3 points, which is, does it predominantly appeal to a prurient interest or some sort of shameful and morbid interest? Is it patently offensive based upon the community standards as a whole, as for minors? And also, is it as a whole, does the book material, whatever you have, does it lack serious literary artistic value? So I'm not saying you don't look at those certain passages, because that's almost like how you start the analysis. But that just is the start of the analysis. It is not the analysis.
But I think, like Jennifer was saying, if we can't read it out loud to adults, to me, that would mean that it's against our standards. I mean, would you not agree that if I can't read it out loud, and because it's offensive to
I'm going to say, I don't know what that means, what you can and cannot read out loud. I can tell you what the statute requires.
Well, there'll be FCC broadcast restrictions saying that this is not acceptable to read out loud.
Right, agreed. So in Indian River County, again, that's my county, I can only speak for them, and that's what I know, is they said that we are not allowed to read obscene from the podium during public speaking. And that is why we challenged many of our library books, because they are obscene and we are not allowed to read them at the school board meeting because they're deemed obscene, and that goes against the regulations for public comments. So again, I mean, if you look at the definition of sexually explicit conduct, that's including sexual intercourse, genital to genital, oral to genital, anal to genital, whether the person's same or opposite sex, bestiality, masturbation. So that's all of these things that we are discussing. But again, somebody's interpretation of harmful to minors may not be the same as every single person in this group. So I feel that if it is not clearly defined, we're going to continue to have this issue in the country and in the state and with this training, because it's up for interpretation.
I feel like the conversation about reading in a public forum to mass people where you don't know their ages, and at like a school board meeting over FCC, you have young children, you have olders, people aren't choosing to listen to you, whereas a 17-year-old, 16-year-old who is choosing to read a book for their own private reading, I think we need to separate the reading out loud in a public way, because I don't think that those are we're not comparing apples to apples there. I've got a little, yes. So I think that's an unfair comparison.
I think we need to know that we as a group are not going to be able to come to a consensus on what, on these issues. And I honestly do think that the best possible way to move forward is to simply put the statute in the training, and then districts can make their own, using the statute and of course following all of those guidelines, they can make their own decisions as far as what, constitutes, what meets the standards of that statute or not. I personally do not see any other way to move forward. And I feel like we have been very stuck on this issue since the beginning. And there are a lot of other things that we need to discuss for this training. So unless somebody has a better idea on how to move forward, I'd like to propose that we move forward at this time.
Could we explore the idea possibly of just simply writing out what it is we're talking about when it comes to age appropriate? If we're going to say that some of this is appropriate, should we at least put a minimum age on some of this of what isn't appropriate? I know some school districts, like in Texas, have spelled out, like, let's say bestiality. Wouldn't be appropriate for anybody, but something
Again,
else.
That's outside of the scope of this committee. And again, that's something that districts can decide if they want to do that. It's not within, it's not within our scope of work.
We are also asked to use peer reviews, and peer reviews do suggested ages. So I think that helps guide our media specialists as well by state statute.
And Amber, I agree with you. I mean, we have the purpose is to create this training, and I think it's really beneficial to hear everybody's thoughts. And we're representing counties from across Florida, which the community as a whole is going to be the community that you're representing. And I think that's really important. I also want to say, Amber, thank you so much for bringing your attorney expertise to this process, because that's something that we've been lacking. We're not attorneys. So bringing that perspective here has been really beneficial. So thank you.
All right. Okay.